Assalamualaikum to our lecturer, Madam Musmailina. We are from Group 3, JAC 2206B. We'll be presenting about Whistleblower Protection Act. This is our group member, Nashatul Afika, Nur Amira Aida, Nur Marina, me, Nur Hanan Atirah, and the last one is Nur Humaira Husna. We start with introduction consists of overview of Whistleblower Protection Act, the purpose, advantage and the disadvantage. The Whistleblower Protection Act of 1989 is a law that protects federal government employees in the United States from retaliatory action for voluntarily disclosing information about dishonest or illegal activity occurring in a government organization. This law, sometimes called the WPA, also prohibits a federal agency from taking action or threatening to take action against an employee or applicant for disclosing information that he or she believes violated a law, compliance rule or another regulation. The disclosed information could include reports of management wrongdoing, the waste of funds, and abuse of authority, and a potential risk to public health or safety. We move to the purpose of the Whistleblower Protection Act, an act to encourage the prevention of corruption and other wrongdoings and facilitating public disclosure of inappropriate behavior and private sector in order to protect those who make those disclosure from unlawful discrimination in order to provide for the matters reported to be investigated and dealt with as well as other matters. We move to the advantage and disadvantage of the Whistleblower Protection Act. For the advantage, exposing unethical behavior. In both government and business, the whistleblower performs a crucial task. Whistleblower can expose unethical or illegal behavior by business and government organizations so that those responsible can be held accountable. Criminal investigations, civil lawsuits, and media attention can change the conduct of organizations like yours by bringing them under more scrutiny. Companies and government agencies who participate in similar malpractice may have previously thought they could get away with their unethical action, but the reform that can be brought about as a result of the whistleblower efforts. Legal protection. Employees who disclose infraction of several workplace safety, environmental, financial reform, and securities law are protected by the federal government whistleblower protection program. Employees who report their employer improper conduct are protected by the program against reprisal. Retaliatory action include being fired, demoted, deny benefits, and having your hours of work reduced. Business who break whistleblower protection rules risk fines, the termination of government contract, and civil litigation. For the disadvantage, first is diminished career prospect. A whistleblower case increased visibility for the employee and the business may not be beneficial. The career prospect of a whistleblower may be impacted by media appearance, court testimony, and government investigation. Whistleblower may be viewed as heroes by the general public for exposing unethical activity, but business insider and recruiting managers may view them negatively for failing to keep company secret and industry practice a secret. The whistleblower can end up being blacklisted in his industry as a result of the media attention. Next is personal complication. Whistleblowers frequently experience personal consequences for their act, even though they may realize that their revelations are for the greater benefit. The personal life for the whistleblower will be further explored by media outlets looking for a story. They might need to retain attorney to defend themselves if criminal investigation or civil action filed against the corporation present legal issue. They can also face retaliatory threats from former managers and co-workers. Significant health issues and relationship fractures may result from all of this additional stress.
Hi, I am Nur Humaira Husna and I will explain about one of the issues of development in auditing regarding Whistleblower Protection Act 2010. This case is about corruption and fraud, where the financial scandal in the early 1980s involving Bumiputra Malaysia Finance BMF, which led to the murder of its internal auditor, may have been uncovered before such a fatal occurrence had there been a decent whistleblower protection law in place. So, due to the fact that corruption is typically covered, it is challenging to fight it when there is a lack of access to important information that could serve as insider or confidential information. In numerous cases, the Anti-Corruption Commission (MACC) examples vary depending on the details provided by those prepared to speak out and provide information to enforcement organizations for corrupt or organized crime. And whistleblowers are those who make such disclosures. Whistleblowers to the Securities Commissions are guaranteed secrecy with regard to their identity and information under Section 140 of the Securities Commission Act of 1993. The Capital Markets and Services Act of 2007 provides auditors and CEOs with further protection based on the Securities Commission Malaysia website. Also, whistleblowers who reveal any fraud in the public domain are also given the same protection under Section 65 of the MACC Act 2009. The government passed the Whistleblowers Protection Act 2010 to supplement the already existing legal system. And whistleblowing in Malaysia is still uncommon compared to the volume of complaints received by various enforcement agencies despite the establishment of several legal frameworks. Based on the case or scandal, there are two arguments that have arisen. The first one is limitation of the act itself. The law has its limitations and make it risky to be a whistleblower in Malaysia because whistleblowers cannot reveal information covered by secrecy laws like the Official Secrets Act OSA of 1972, the Capital Markets and Services Act of 2007 and Section 203A of the Penal Code. Because there is a lack of independence because the minister has the authority to direct the enforcement agency's actions and these agencies are required to follow such directions, claims the executive director of the Centre to Combat Corruption and Cronyism. Additionally, there is a natural reluctance to blow the whistle due to the excessive number of instances of retaliation, retribution, harassment and arrest. It is thus risky to disclose information in Malaysia unless these restrictions are properly addressed by giving whistleblowers suitable protection and a method for exposure. The second argument that arises is the status of the whistleblower. The difficult decision of whether to recruit a whistleblower or consider him an employee who has shown unloyalty to his prior employer is one that corporate leaders frequently have to make. This argument is based on the idea that if public disclosures are made without adequate regard for the impact on the organisation, whistleblowers could endanger the reputation of the organisation. However, there are findings that prove that corporate fraud had been successfully combated and unlawful behaviour has been the subject of investigations thanks to whistleblowing.
Next, I will moving forward to the suggestion to improve whistleblowing in the company. The first suggestion is that the company should create a speak-up culture. This culture is aimed at preventing wrongdoings before they occur. A true speak-up culture encourages employees to raise issues with the understanding that they will be treated fairly and adequately. The second recommendation is to make a resolution system. A company should create a system for resolving reported violations that protect the whistleblower. In this way, the whistleblower may report the issue without fear of retaliation. Next, a company should train employees on their rights. Employees should know their rights when it comes to whistleblowing. For example, employees must be exposed to information on internal and external protection programs. Therefore, they will be more brave to report the issues in the company. Lastly, one of the suggestions to improve the whistleblowing is to use an independent auditor. A company should hire an independent auditor in order to determine if the protection program provided is effective. A company should always make sure that their protection programs are worth it to avoid various problems arising in the company.
Okay, now I will proceed to the whistleblower as an internal auditor. The whistleblower was then hired as an internal auditor. It is divided into two parts. For starters, an internal auditor acting in a trench role where it is established and trusted with a blowing hotline are likely to experience an increased number of calls and takeoffs. As a result, it is important to have a process in place for evaluating and prioritizing reports. Therefore, the internal auditor should follow the following recommendation with a risk-based approach. Okay, first and foremost, in the initial capture of the tip-off is crucial. All reports should be acknowledged and responded to as soon as possible. The second recommendation is to prioritize the report based on risk. While allegations of fraud or corruption are always serious, consenting to health and safety or environmental violations may be critical depending on the circumstances. The final suggestion is to delegate a report that reflects misunderstanding, personal grievance, or minor errors to a support group such as a human resource that can handle them efficiently. Okay, next. Following that, an internal auditor will serve as the investigator. It is critical for the whistleblowing program's credibility that all disclosures are promptly and truly investigated. Internal auditors frequently conduct investigations, particularly those involving fraud. So, the key recommendation for the internal auditor is to first commit to truly, fairly, quickly, and confidentially investigating all matters. And second, recommendations for further disciplinary or police reporting are made. And finally, to maintain a feedback loop to whistleblower, the entities known as whistleblower should be kept updated on progress and outcomes, and the following interview should not be ignored.
In a conclusion, the Whistleblowing Act has expanded in its roles, purposes, and essentialities to include not just the business operation procedures and government structure, but also government bodies and states government. The implementation of an effective whistleblowing policy has become a requirement for every organization. Whistleblower Protection Act 2010 has served as the muse for the whistleblowing technique in Malaysia. With the lifestyle of the act, many human beings have ended up courageous and lead forward in blowing the whistle. Moreover, employers may also have placed a whistleblower or stress them into quitting. Whistleblowing needs to do with ethics. As a result of it represents a person understanding at a deep level that associate action their organization taking is harmful, that interferes with people's rights, or is unfair or detracts from the common good.